Welcome back to HOA Hell. I'm your host, Michael Kushner, and with me is Senior Associate at MBK Chapman, Sam Kill. Sam, good morning.
Good morning, Mike. Good to be with you.
Thank you for being here. Sam, we have a good one today. We're going to talk about AB 130.
Oh, yeah.
That has caused major waves throughout the HOA community in California. It went into effect on the 1st of this month, so basically July 1st of 2025. And although it is considered by some to be a boon on behalf of homeowners, it's actually one of the stupidest laws that has been passed by our legislature in a long time. It was such a poorly drafted law. And we're going to talk today about how poorly drafted it was and all the holes that it left. It's going to wreak havoc, and it's going to be worse for homeowners, and it's not going to help them. And the funny thing is that you have some lawyers that do what we do at this firm, even including some that I've trained, that tout themselves as HOA experts and that they're leading HOA lawyers. And he wrote his own article where he even implied very strongly that he helped get this thing passed. It is strongly implied in that article that he had something to do with getting this passed, and he didn't, because he didn't cover any of the downsides and the unintended consequences that are going to result. This is not a win for homeowners. This is bad. It is so bad that this has crossed the aisle. Not only do intelligent attorneys that represent homeowners hate this law, but the lawyers that represent the HOAs hate this law too. It's really, really bad.
Definitely. Yeah.
And I'm going to tell you why. Now, I wrote a very lengthy article that you can find on our website at mbkchapman.com. I wrote a lengthy article about AB 130 already. So this is just our podcast. I usually do it in reverse. I usually do the podcast first, then the article. I did it backwards.
And the article is really good. I really urge the audience to go check it out on the website.
Well, thank you.
It's very good.
I work very hard on these articles.
It's very comprehensive, yeah.
Okay. So we're going to go through basically what AB 130 says. We'll start with that, okay? AB 130 went into effect on June 30th, so really July 1st, okay? And it made a major change to Civil Code 5855. And here's the thrust of it. This is the problem. 5855 existed, okay, before. But it modified 5855 and put a cap on the amount that an HOA could fine somebody to $100.
Right.
Now, on the surface, that would solve the problem of excessive fines, which is a big problem. Don't get me wrong. Misuse of fines and HOAs issuing excessive fines has long been an issue in California. We've talked about it in prior podcasts, haven't we, Sam?
We have, definitely. Yeah.
But the things that this statute didn't say is what creates the big problems. It didn't anticipate any of the problems that would result from this. And that's the sin here. So I'll just give you a taste, okay? What counts as a single violation? Because it limits it to $100 for every single violation.
Per violation, yeah.
By the way, there is an exception, which is largely irrelevant for our purposes today. If the rule or if the violation threatens health and safety, and the HOA can jump through the necessary hoops to prove that, then the fine can be more than $100.
And if it's significant or imminent.
Yeah.
Right. Yeah.
But that relates to health and safety. We're not going to talk about that exception today because it's really, the hoops you get to jump through to even meet that exception are kind of stupid anyway. I'm just disgusted completely by this entire law. It was dumb. But when I explained to you why it was passed and what was behind the governor signing this, you'll understand that it had nothing to do with helping homeowners and HOAs. It had everything to do with a social and environmental policy that this governor and our legislature has had for years in California, and that is the increase toward urbanization and the anti-suburb feelings that generate strongly through our legislature and our governor. That's where all this came from. And the people that are rah-rah for this law think it's going to be a boon to homeowners just don't understand. They just don't understand the law. Lawyers and lay people alike.
It's pretty short-sighted, yeah.
Yeah. So what about escalating fines? Silent.
Not addressed, yeah.
What happens if it's the third, fourth, fifth? You've done the same thing 5 times. You're a recidivist, right?
No nuance, no specificity at all. Yeah.
Can they be fined again for the same violation?
We don't know.
I don't know.
Yeah.
Okay. What about fines for ongoing issues that
Right.
have been resolved and then restarted? Somebody promises to do something and then 2 months later decides to bring back the illegal vehicle.
Unclear.
Okay?
Yep.
So while this law gives the appearance of protecting homeowners, it's not. So let's talk about how AB 130 makes compliance harder, not easier. Let's be clear. AB 130 doesn't stop bad behavior at all, okay? And we don't know whether HOAs can still use an escalating fine schedule, which is if you think about it, and this is going to be the problem. Innocent homeowners who are following the rules are going to be the victims here, because you're going to have people who, and we're going to talk about this a little later, but you're going to have people who are going to look at a $100 fine and go, you know what, I'm just going to ignore the rule and do what I want, and I'm going to include this as the cost of doing business.
Right.
And without the ability to escalate those, okay, first offense, $100. If you don't fix it, it's $200. Then it goes to $500, and then $1,000. If you don't allow HOAs to do that, then the rules might as well disappear.
You take a major deterrent off the table.
You've taken off.
Yeah.
What's going to happen is we're going to see and this is great for my business, by the way. So you could tell I'm really on your side here, because this is actually going to be great for me. Because you know what's going to happen? HOAs are going to start filing lawsuits. Mm-hmm. Lots and lots of lawsuits. Because at least then, when they prevail, they show it's a violation of the rules, they prevail, they're going to get their attorney's fees. Mm-hmm. So they're going to sue. In places where they never would have sued, they just would have gone to escalating fines.
Yeah.
And then foreclosure, or even if they had to do it non-judicially, or judicially, I mean, right, for fines, for example.
Fines, yes, correct.
They're going to start filing lawsuits for breach of governing documents. You're going to see a whole bunch more of those. It's the only way they're going to have to enforce. So of course they're going to do it. So that deterrent's gone. Mm-hmm. You have the only deterrent is gone. Okay. I guess if you live in a community that has a lot of amenities, like a condominium community, I guess you still have the deterrent, which was silent in the statute. So I guess it's not affected by AB 130. The amendment to 5855 would be they can suspend you, but from using different amenities. But that's nothing. Money talks.
Right.
Okay. So boards are going to have two options: do nothing, because people are now, for example, I want to build my deck. Okay, I decide you don't let me. You say no, it violates architectural standards, blah, blah, blah. I build it anyway. You fine me? I don't care. $100. Mm-hmm. Cost of doing business.
Yeah.
Now, sue me. That's all there's going to be left. And who's going to pay the price for that?
The homeowners.
Everybody.
Everybody, yeah.
You guys are going to pay the price for this.
Yeah.
Okay? For this folly. So this is a law full of holes and no guidance for enforcement. So let's talk about what AB 130 didn't say. You got any? We talked about a couple.
Yeah, it doesn't really define per violation, really,
what does that mean?
With nuance. I mean, is an ongoing violation a singular one? At what point is the cutoff, right?
Right.
If it's unabated, uncured, and then...
Yes. What about a Monday I do something, like I have my trash can, or let's do something more egregious. I have a party on Sunday that's really loud, right? Mm-hmm. Okay, so Monday I have another party, right? I guess you could argue that's a separate violation.
Right.
But it's also for the same thing. I'm not sure. Let's assume I'm going to interpret it as being a separate violation, but I don't know. I don't know what it is. Or let's say it's something that I haven't abated at all. Let's say I have the party. Let's say I just have the party going and I don't stop. It starts on Sunday and it's still going Tuesday. Okay. Is that one violation?
Yeah. Your dog's being too loud. Ongoing issue
every
with the
day.
dog.
Neighbor
complains.
Is it every 24 hours?
Yeah.
Every 12 hours?
When does it reset?
Every 48 hours?
Exactly.
Right. And these are things that, let's say I put up a pergola and I block somebody's protected view. Mm-hmm. They have a view protected in our governing documents and I block it completely. Is that one violation, or is every new day a violation? And who said?
Right.
Where does it say that? They didn't address it at all. Just silence. Mm-hmm. Okay? It gets much dumber. By the way, we're just at the tip of the iceberg.
Well, a big one is a progressive fine one. Whether it's currently ongoing with current enforcement actions, what happened to those? Or moving forward, if you have, let's say, a violation and it persists, at what point do you, you don't get to escalate it.
Well, here's another thing. They said $100 maximum, right? Mm-hmm. But a lot of HOAs have fine schedules. Say, okay, first offense, $50, second offense, $100, third offense, $150, then $200, then $300, and then, and if you ignore, there's a penalty there's a cost. Now, those are up in the air. As far as I'm concerned, those are gone.
Right. Mm-hmm.
Okay?
So it reverts back, even if you're at a higher tier pursuant to that policy, it reverts back to a $100
it's unbelievable.
Element. Yeah.
It's ridiculous. It also didn't address what happens to fines that were already in place before this went into effect, before June 30th. I don't know. because they didn't bother thinking it through.
Right.
Because, again, their goal wasn't to improve the Davis-Sterling Act. This is a loss for homeowners and HOAs.
Yeah, the lack of forethought as far as, deeper planning, especially when it comes to common interest developments, that's pretty baffling. Yeah.
And the thing is they're making our lives harder. Our law firm exists to prevent HOA abuses. We are on homeowners' side. But that doesn't mean that we ignore rationality and that we carte blanche accept, homeowners are always right and HOAs are always wrong. Sometimes we're both right. Sometimes the HOA and homeowner's right.
100%.
This is one of those cases.
And no one wants a flood or barrage of lawsuits if those can be avoided.
No, because it's going to cost everybody money. The insurance company is not going to. Let me tell you something. When an HOA gets sued by a homeowner, insurance company steps in and provides a defense. But when an HOA has to file a lawsuit against a homeowner, the HOA is paying for that. That means you're paying for it. Special assessment time, because instead of one lawsuit a year, you might have 20 now. This is going to increase lawsuits. I promise. It will.
And it's likely untenable
for
many communities.
I don't see how it's going to last.
Yeah.
And it's going to take time for the courts to interpret the law and start actually creating the real law, which is how our system works. The legislature has to amend this.
Yeah.
It's that bad. They just have to. So he brought up escalating fines. Mm-hmm. I don't even know if that's legal now. We don't know. I assume not.
It doesn't look like it. Yeah.
Okay?
Mm-hmm.
So what happens? Well, you've just rendered $100 is a easy price to pay to get what I want. Okay? So I want to start building something and they don't want to let me, or I want to keep my commercial vehicle. It costs more to rent a parking space for my boat or RV than it does for me just to pay the fine. So I'm going to start paying the fine because I can't escalate anymore. The HOA can't get it up to $1,000 or a daily $100 a day now. Like after, a long time of violating the rule, it gets to a point where it's expensive for me. No, it's $100. So even if they say, no, it's per violation, okay, big deal. I'll pay $100 every time you notice me. You can't do it more than once per, you can only notice me once for every hearing period, right? So at max, 2 times a month if you give me the notice requirements, right?
Yeah, right.
So that's $200 a month max that you can start fining me.
Yeah.
It costs more to rent a place to park my RV. So guess what? I'm parking my boat. I'm parking my RV right on the front lawn. You're not going to be able to stop me because I'd rather pay the $200 a month for the 2 violations I might get, assuming that multiple violations can be afforded here, right? Which we're still not sure of. It costs me more than to pay the violations that would come into effect in time for me to get a hearing.
It may really open the floodgates for abuse on both ends.
It not may.
Yeah,
it will.
It will almost certainly. Yeah, on the HOA board side, certainly for those that are have tendencies to abuse, because it leaves too many questions unanswered, and certainly on the homeowner side.
So just for a minute, just because for fun, let's deal with that one exception. Oh, we're so wonderful. We're going to give you this exception, health and safety. What's health and safety? Does reckless driving through private streets, does that count as health and safety? What about aggressive dog off leash? Is that health and safety? Yeah, I'd argue yes for both of those. What if someone's hoarding attracts rodents or vermin? Is that health and safety? Yeah, arguably.
What's imminent and significant?
That's right.
Who gets to determine that?
More importantly, wait till you see the other requirements in the code regarding, and it is that. They've got to establish that, put it in the minutes, and make a finding of the basis for their health and safety finding.
Yeah.
Meaning that a meeting now has to occur in between. Right. So now you've taken, health and safety is supposed to be, if it really is a health and safety issue, then how could you have to wait for a notice meeting? Wouldn't it be an emergency? I mean, if something really does threaten health and safety to the point where it fits under an exception, then why is this, take your time. This will take several weeks to get out. Look at the code, guys. Read my article. My article goes through it beautifully, okay? I didn't want to make this a 2-part episode. I didn't want to make this an hour episode. Yeah. So we're kind of jumping through things. So I am counting on you listeners to read my article. I go through it all in painstaking detail. But there's no definition. And when you don't define your terms, you're leaving it up to individual board members, individual people. In other words, different courts are going to come up with different definitions because everybody's different. There's no bright line. There's not even a blinking line. It's a non-existent line. It's just insane.
And I seriously doubt that these guys spoke to or consulted with a serious, competent attorney on either side of the aisle, on the HOA side or the homeowner side?
This was one or two legislatures who threw this in thinking, we'll get to that later, okay? So let's talk about, here's another question I have. We've kind of danced around this. We talked about escalating fines and we don't know. What about those when you finally get to the point where you're at a per day fine? Does this cap those too? Does this limit them or prevent them? For example, I have my commercial vehicle parked in my driveway. I don't move it. So I'm fined $100 max. But then it gets to the point where I've ignored it. And now, can they start fining me $100 a day?
I'm not exactly sure.
I don't know.
Yeah.
If not, I promise you he's never getting rid of that because parking somewhere else is going to be more expensive. Unless you allow that, unless you make it more expensive for them to move the vehicle or keep the vehicle there than it is to move it, they're going to keep it there. I would.
Could this foreseeably lead to revising rules and governing documents to
It requires the revision of governing documents, including the fine schedule.
Definitions and all that stuff, yeah.
This is just, again, there's literally nothing good about this law. Nothing. Not even the $100 cap, because it does more damage than good. Okay? So we don't even know if the continuing fine or the daily fine model is legal. We don't know. We have zero information, but it looks like not legal based on the wording of this statute now. Okay? So no clarity, no consistency. And let's talk about real world impact. We've already kind of hinted at it, haven't we? This is going to, by the way, this isn't just going to impact bad HOAs, as some lawyers like to say. This is going to impact good HOAs and good homeowners and good members. Who's going to benefit from this? Let's talk about actually applying brains to this scenario instead of a knee-jerk reaction like a lot of lawyers have done that are pro-member lawyers have got this knee-jerk reaction about how great this is because they haven't actually thought it through.
We are absolutely 100% pro-member.
100%. We are on member side. This is what I dedicated my career to.
Yeah.
But this is not home member or pro-member. Do you know who this is going to help, this law? Only one type of member, the chronic violators.
Yeah.
This provision is fantastic if you're a chronic violator. Then you're going to love this. For everybody else, it's going to be hell.
Yeah.
Okay? I'm speechless.
Hang in there. Yeah.
I am. I'm speechless. Let's just, I'm going to just leave it at that. The only homeowner that this is good for is the bad homeowner, the chronic violator. This does not curb HOA abuse at all.
Yeah.
Because in the large scheme of things, the abuse of fine schedules is not one of the most serious issues that bad HOAs engage in. It is an issue. We talked about it in the past, but it was easily fixed. But this wasn't the fix, okay? So let's talk about this, the new addition. We talked in a prior podcast about the fact that you as a member do not have the legal right to have a lawyer present with you, either at a board meeting or at a hearing, a disciplinary hearing. Now, we talk about the fact that most HOAs allow their people to bring their lawyers.
Right.
But they don't have to. Well, here's the thing. One of the changes in AB 130 was if an agreement, or basically it talks about an agreement being reached at the disciplinary hearing. In other words, if the homeowner and the board can't reach an understanding as to what the charges are and what the punishment should be at the hearing, they don't come to an agreement, the HOA has to jump through a bunch of hoops. This changes things radically. Number one, it actually, normally what happened is you'd go to the hearing, then you'd leave, and then the HOA would meet in executive session, and then in the next 15 days, you'd get a notice about the results of the hearing. But now, because of the wording of this law, it sort of requires them to have the homeowner step out so they can discuss it in real time. Come to a decision, announce the decision, and then do you agree with this?
Right.
And if not, the HOA's got to jump through a bunch of stupid hoops, which the homeowner already had a right to, like IDR, which already existed.
Yeah.
Forget that. Right. Now it's mandated within this.
Exactly.
But if they come to an agreement, it is enforceable like either a settlement agreement or a judgment by the courts. It's enforceable by the courts. And here's the due process problem. You do not have the right to have a lawyer present with you, but you might very well be pressured into signing a legally binding document without a lawyer there, without your right to a lawyer there.
Yeah.
that is, you can be held enforceable against you by a court. That's insane. Because I promise you this, the HOAs are now going to always have the lawyers present at these, so that the lawyer can be present during the drafting of this agreement.
Or they could have pre-approved templates and forms.
That's right.
And they have that advantage to your prejudice, and you have not consulted. You're walking into it being blindsided, and guess what?
Right. And no lawyer.
And it's bound. You're bound by law because it's tantamount to a stipulated judgment that you're committing to. So,
It's all new, people. They didn't, at the same time that they said this, they didn't say, and homeowners now have a right to have counsel present if they choose at a disciplinary hearing. They didn't add that in. They left it silent, which means that the law in that respect didn't change. So what does that mean? It means that the HOAs, two things it means. Not one, the HOA is going to either have their lawyer present all the time, which they always have a right to do, but not give you the same right. Or, like Sam said, they'll have pre-printed forms that you've not seen, but they've been vetted by the lawyer. But also, it's going to increase costs tremendously because that lawyer charges by the hour. And instead of appearing at one of 10 hearings, he's going to be at every hearing. And HOAs are going to pay for it, which means you're going to pay for it. So now dues are going to go up. Assessments are going to go up. Why? Because this is more expensive. And the HOA isn't going to go into, the board's not going to go into these hearings blind if they're going to be bound by whatever agreement might be reached. In the meantime, you as a homeowner have no due process because your right to counsel is not established.
Exactly.
But you can be held liable for what you agree to. It can be enforced by the court. That is insane. I don't think I can overstate how stupid that is.
I mean, that asymmetry is arguably unconscionable.
It's
it's
beyond stupid.
Right.
I agree with you.
Yeah.
Stupid wasn't a good enough word. Unconscionable is a better word. Okay? It's insane. It's insane.
Well, the other question that comes to mind, and just kind of free flow discussion, what about under-resourced associations or smaller ones? I mean, both large and small will have, they won't even afford it. So then what do you have? I mean, you have a state of flux, or you're like in a state of limbo where the vast majority of members are good members. They're not abusive, right? They will not take advantage of these types of laws and perpetually engage in violations, knowing that it's a cost of doing business and they're capped at $100 for that violation, arguably. Now the neighbors are prejudiced by it because they're subject to this nuisance, and meanwhile their under-resourced HOA board can't enforce.
And these neighbors are going to have to. So let's say the HOA doesn't pursue this because it can't afford to, or doesn't want to file a lawsuit against everybody.
Yeah.
The neighbors, because you have a right to enforce governing documents.
Yeah.
The neighbors are going to have. You are going to have to file more lawsuits too.
Burden passed to you. Yeah.
So basically, here's what's happened. If we're going to give the long and the short of it, the only people that benefit from this law are abusive HOA members. Bad HOA boards aren't affected by this law at all, really. It doesn't really matter to them. There's other ways that they can screw with you. And this is not even one of the major things. Excessive fines is maybe number 10 out of 15 things that HOAs do really wrong, right?
Yeah.
It's not even the top 5, okay? Failure to maintain. The things we've talked about in our other podcasts are much bigger problems than excessive fines. But what you're going to do is you're going to incentivize bad HOA members to calculate the fines in this cost of doing business and just do what they want. So HOAs are going to be faced with decisions to file multiple lawsuits, which they may not be able to afford to do or won't do, in which case homeowners are going to have to live with it, or they're going to have to file their own lawsuits to enforce the governing documents. And of course, if they win, they get their attorney's fees, but that's after spending 6 figures. Theoretically, right? If it goes all the way.
Exactly.
Most cases don't. 95% of cases settle, but it could.
Yeah.
The bottom line is this is going to cost HOAs a lot more money. It's going to cost you a lot more money. It's going to benefit only bad HOA members. It will not curb HOA abuse, except in this one small sliver.
Yeah.
And even then, they're going to find ways to abuse all the things we've talked about that were left silent. They're going to assume that they can do certain things until they've been told they can't. Mm-hmm. So they're going to abuse it that way. So really, bad HOAs could also benefit here, I guess.
Yeah.
So the only people affected by this are bad HOA members and bad HOAs. Who's helped? Nobody. But the bad ones.
Well, arguably litigation attorneys.
Yeah. Oh, it's going to make business better for me.
Yeah. Right.
It's going to bring more business to my law firm. It'll bring more business to the HOA side law firms. But it's going to cost you people, you listeners, you homeowners that live in HOAs, I do too, by the way, it's going to cost us more money. It's that simple. But this unconscionable shift in due process that nobody, as far as I know, has even written about it except for me. I think I'm the only one that brought that up in my article. Okay? I looked around, I couldn't find anything. It's so new, it just people haven't had time.
I was really curious, and I certainly looked on the HOA representation side and their websites too on how they cover this issue. And I was somewhat surprised that even they are very, how should I put it, in a very short version of the essentials of what AB 130 does, but not really a deep level discussion.
No, I saw one too that was like a few paragraphs about how bad a law it was.
Yeah.
Nobody went into depth like I did in the article.
I mean,
I did a deep dive. That's why I didn't publish it right away. I didn't race. I was obviously aware of this. I didn't race to publish this because I needed time to think it through. I sat and thought about these issues. I thought of all the things, all the problems that this is going to cause. And then I thought, okay, am I wrong?
I do want to credit you for a brief moment. And
I'm not fishing for that.
No. And neither are you doing that, nor is this planned. The impulse on the attorney side is to be profit-oriented at times. You took a moment to really pause and give it, a deep level thought as far as the nuances and what broader implications this will have, both from a public policy perspective, but specifically this industry as a whole, regardless of which side of the aisle you're on. And I credit you with that because some of this, it's undisputed. It's really,
Thank you. Part of what made me write my article first, okay, as opposed to doing the podcast and then thinking it through. And then when I thought about it and I came up with the due process issue, that's what staggered me. I didn't come up with that right away. I came up with that while I was thinking it through. Holy moly, this is bad. And he couldn't even see it because I don't think he took the time to read it. I'm still not convinced to this day he's read the statute.
I mean, as with most, new developments in this realm, as far as legally in the legislature, I think it behooves people to take a moment to really reflect and pump the brakes before rushing with an impulsive marketing scheme or, a cursory discussion of it that's superficial.
Anybody from doing that. So I decided I have to write this quickly because there has to be another side to this because I haven't seen a lot from the home owner side on this other than this other one. I didn't see a lot of articles on this yet that were anything other than reporting that it went into effect. Okay. Yeah. But this is bad enough where if I'm a homeowner, if I'm you guys, I'm writing to my state legislature saying, you guys have to amend this. This is stupid. And send a copy of my article. I mean, it just, if nothing else, it's bad. It's bad. It's really bad law.
I agree. It took me a moment to get there, but yeah, I agree.
It's just bad.
Yeah.
And this is going to help nobody but the people that you don't want it to help, the people that are going to hurt other people. So we have this loophole-laden, right? You could drive a truck financial commitment clause.
Oh, yeah.
In the statute. I don't even want to talk about it, to be honest. I'm going to skip that. There's a whole bunch of little hoops that have to be jumped through, which are in the wrong. Let me give you an example. And I'm going to talk very loosely about it because, again, it's all in my article, okay? You always had the right, as a homeowner, we've talked about this in multiple podcasts. If you're ever unhappy with something your HOA's done, you have the right to demand IDR, internal dispute resolution. And if you put it in writing, they have to do it. Your HOA has to agree, or they're in violation of the Davis-Sterling Act. And what's supposed to happen is you do something wrong. You get a letter saying, hey, we learned that you did this and this, or you violated this rule. We are setting a hearing date, the requisite number of days ahead. We're setting this hearing date. You're subject to a fine based on the fine schedule. We, like to hear from you on that day. We'll see you then. Then you show up at the hearing. You present your case. They present whatever side they want to, if any. They present whatever witnesses they have or documentation. You're excused. They make a decision, and they notify you within 15 days. Right. Statute shortened it by 1 day. Now it's 14 days.
14, yeah,
right?
Exactly.
Anyway, who cares about that? But that's the way it's supposed to happen. Now they stuck in a few things. Mm-hmm. One thing they stuck in was
a pre-committal financial to cure. Cure.
You have a right to cure if you commit financially. What does that mean? We don't know. If you promise, all right, I'm committing financially, is that enough? Does that mean the hearing comes off? I can't be fined now? I don't know.
It's kind of like an earnest money deposit.
Right. Suddenly this inter-hearing, inter-process right to IDR. Suddenly you can now torpedo the entire process, demand ADR in the middle of and then timelines start over again? I don't know. It's so stupid as to be beyond reason.
Yeah.
It's as if a third or fourth grader wrote the law. It's that bad because it takes nothing into account, no thought at all. I go through this in the article. I talk about what was really behind this, which is if you look at SB 9 and 10, for example, what our legislatures tried very hard in California to do is to increase urbanization. Suburbs, single-family homes, backyards, everything are bad for the environment. They use a lot of resources, and they don't like them. They'd rather see smaller footprint that way. So they have done everything they can to try to make single-family homes less enjoyable. They tried to pass a law that said that that developers could build apartment buildings in single-family home neighborhoods. Okay, that thankfully didn't pass, but it did is getting rid of zoning requirements. So you can now build, multifamily homes in what was previously commercial zoning. Why? Oh, we have to increase the amount of housing, affordable housing. It's a big problem in California. Well, it's a big problem in California because of government intervention, not because of anything particularly else. So, and because I won't get into why housing's a big problem in California other than people want to live here. There's a lot of reasons why. None of them relate to our zoning. None of them. That isn't a reason. But anyway, that's what underlied all this. It had nothing to do with helping homeowner rights. It had nothing to do with solving a real big problem about the unfair overfining or the fine
caps.
Yeah, the abuse of the fining process that bad HOA boards were involved in. This had nothing to do with it. Nothing. This law wasn't passed because they were listening to the drum roll of these law firms that were implying that they were making all this noise about you need to fix this huge problem. It's not a huge problem. It was never a huge problem. Okay, it's a problem, not a huge problem.
Yeah.
And they aren't there looking at social media and saying, geez, we got to fix this. Let's fix this right now. It's not how this works. It had nothing to do with fixing abuses in HOAs in California, which is why it doesn't do that. It doesn't care about it. It got what it wanted.
Right.
Okay? So the political agenda behind 130, I was going to talk about it in detail. All these things, that's what this was all about, is taking local control away, and that includes HOAs. It wasn't aimed at HOAs. It was aimed at municipal control.
Yeah.
Remember that dispute between Huntington Beach and the state? That's what underlaid all this, okay? Local control as opposed to state control. The state wants more control over local rules and ordinances, and the way to get it is through stuff like this. So that's what happened here.
Yeah.
I'll leave it at that. I was going to go into detail. I'm not going to. Go read it in the article.
Well, this is certainly an unpolished, unfinished product, if you will.
I mean, this was maybe one of 10 drafts. This should never have gone out of committee.
Agreed.
Okay? If you want to cap unreasonable fines, then do that. There's ways actually, it's not hard. I could write it in a couple hours. I'll write the law for you in a couple hours. It'll make sense.
Mm-hmm.
And it won't create unnecessary or unreasonable or unknown conflicts. And it won't create these big questions because I'll sit and think. I'll use my brain, number one, and I'll think about all the issues like I did. I don't think I can say enough bad things about this law. It's going to hurt the very people that I have dedicated my career to helping.
Yeah.
Homeowners.
Yeah.
It's going to also hurt HOAs too. It will. But it'll hurt the good ones more than the bad ones. And it'll help the bad HOA members. It'll help the people that create the problems in your neighborhood. They're going to benefit. And a bad HOA is going to benefit because they'll interpret the law the way they want to until they're told they can't.
Right.
And in the meantime, they'll run roughshod using all these ambiguities in their favor. So thanks for nothing.
Yeah, the absolute certainty here appears to be the net cumulative or aggregate effect across the board will be greater cost, right? Greater economic negative impact to the broader members within HOAs.
That's right. It's just going to be more expensive. Dues are going to go up. Your HOA is going to pay
special
more for
assessments,
lawyers.
insurance, all of it, yeah.
Everything. It's going to be a cascade. It's going to take a few years to kick in all of this, but you're going to see it. If this law is not amended, seriously amended, within a relatively short period of time, within a couple of years, I'm going to be proven correct on this.
Or the courts weighing on it relatively quickly.
Then, in order to do that, it's got to wend through the court system.
Yeah.
Okay.
It'll take too long.
And that's going to take at least 2 or 3 years.
Yeah. At this stage, I mean, I think this is good. The article is really a deep dive, multifaceted. Again, we want to encourage the audience to go check it out, including any industry professionals, regardless of which side you're on. I think the article is still pretty well written and balanced. And guess what? It's so bad. I agree with you. The law and so many disconcerting elements about it that, guess what? We'll likely do multiple additional episodes.
I might do another podcast as a follow-up. I'm hoping that there's enough backlash where the legislature takes a quick look at this and amends the law quickly.
Right.
I'm really hoping. Folks, we're here to help. It doesn't mean I'm 100% of the time I'm going to be on HOA member side against HOAs. It's not always the case. I'm here to tell you the way it is, not the way you want to hear.
We call it like it is. Yeah.
So if you like this episode, please hit the like button and be sure to subscribe to the channel, HOA Hell, if you haven't already done so. If you want to leave a comment, especially on this issue, I would love to hear from you. In fact, I'd love to hear from anybody that's going to take a few minutes to go read the statute and leave a comment and tell me what you think. Tell me if I'm wrong or if I'm right. If I'm wrong and you make a good case, I'll present it on the air. Other than that, until next time.